But 8:30 being the time now, time for the Law Report with Damien Carrick. Good morning, Damien.
Good morning, James.
Last week's federal court decision against columnist Andrew Bolt certainly ignited an enormous debate on the issue of freedom of speech.
It certainly has. Last week, the federal court ruled that 2 articles by journalist Andrew Bolt, published in the Herald Sun newspaper, breached the Federal Racial Discrimination Act. So was Justice Bromberg's decision a slap in the face for freedom of expression, or a measured response to an offensive racial slur? Professor Adrienne Stone is the director of the Centre for Comparative Constitutional Law at the University of Melbourne. She says the 2 articles at the centre of the legal dispute name a number of people with mixed heritage and go on to state that they chose to consider themselves Indigenous in order to further their careers.
The 2 articles drew attention to a group of fair-skinned Aboriginal people who were in various ways prominent in the community. Some were academics, some had been activists, some had been artists. And the articles, one of which was entitled "It's So Hip to Be Black" and another which was called, I think, "White Fellas in the Black," drew attention to the fact that these were people of mixed ancestry who identified nonetheless as Aboriginal. And the decision to identify as Aboriginal was subject to very strong criticism by Mr Bolt in these articles, and partly on the basis that, in his view, these people had benefited in terms of their careers by having available certain benefits to them by virtue of their Aboriginal identity.
So they'd latched onto that Aboriginal identity in order to further their careers. That was the implication.
Yeah, to be absolutely fair, I think I should point out that there was some dispute amongst the parties as to how to read these articles, but the judge found that the articles contained an imputation, that's the sort of legal word for what they meant, an imputation that the persons described in the article had made a deliberate choice to identify as Aboriginal people in order to further their careers.
And what was the tone of the articles?
The judge describes it as satirical, mocking, sarcastic, and I must say so on my own reading that I found them to be exactly of that nature.
Were these articles factually accurate?
One of the strongest criticisms in the judgment of Mr Bolt is that there were numerous factual inaccuracies, and that became very significant in the outcome. So, for instance, although there is imputation in the article that the individuals described made a choice to identify as Aboriginal, all of them led evidence, which was not challenged by Mr Bolt, that they had identified as Aboriginal since their childhood and had upbringings in which they were identified as culturally as Aboriginal, and that they were recognised by their communities as Aboriginal. So there was clear evidence of false statements on those bases. There was also exaggeration in relation to the benefits which Mr Bolt said these people had received as a result of their Aboriginal identification. For example, in relation to one plaintiff, he described her as having received plum jobs reserved for Aborigines, when actually one of these jobs was an unpaid voluntary position, and the others were positions that were open to all applicants, although Aboriginal people were encouraged to apply for them.
Were there also mistakes about the actual ethnicity of people's parents?
Yes, there were some very prominent mistakes. I think it's been very widely and reported in the press, for example, that Mr Bolt made the claim that one of the plaintiff, Professor Larissa Berendt, that her father was German, and in fact, this was not contested at the trial. Her father is Aboriginal. And so the accusation about her mixed ancestry was somewhat inaccurate. And lastly, could I say, it was significant to the judge that there were some, what he described as gratuitous asides. So in relation to one of the plaintiffs, for instance, and this was Mark Macmillan, there were some sarcastic comments made about the fact that he was gay that contributed to the judge's ultimate finding on these issues.
Now, the plaintiffs brought an action for breach of the Racial Discrimination Act. What breach were they alleging?
So there's a section in the Racial Discrimination Act that makes it unlawful, not criminal, but unlawful, to do any act that would offend, insult, humiliate or intimidate a person or a group of persons, where that act is done because of the person's race. That's Section 18C, and that was the section under which this action was brought.
Now, Section 18D contains a number of exceptions or exemptions. I'm not sure exactly which. In certain circumstances, you can still say these things because, surely every piece of language which is offensive and humiliating shouldn't be unlawful. What are those exceptions?
The most important one for these proceedings is that it is possible to make a statement that's offensive or humiliating, or any of those other concepts in the Act, so long as you do so reasonably and in good faith in the course of making a fair comment on a matter of public interest.
And presumably that defence would have been run.
That defence was run and was a subject of a lot of attention in the judgment. And the judge found that the defence of fair comment, which is also a defence that you'll find in the law of defamation, requires that commentary be made on the basis of true facts, and that because of the factual inaccuracies, this could not be characterised as a fair comment. He also found that there was a lack of reasonableness and good faith on the part of Mr Bolt because of the inaccuracies and also because of his mocking and satirical tone.
Now, look, I understand that the Herald Sun argued that, a few things, that the people identified here all had a public profile and they were legitimate subjects of public scrutiny. Some had jobs, prizes and awards which were publicly funded or partially publicly funded. And there's also a legitimate public debate to be had about whether or not there are more deserving recipients of some prizes and awards than other recipients.
That's right. And let me be clear, I think that that's a very important point to understand. There is a really important public debate to be had about those questions, and I don't think that the judgment denies that. In fact, Section 18D, the defence section, is exactly there to ensure that a public debate of this kind can be had. But it can't be had at all costs. It's possible to engage in a discussion about race, engage in a very critical discussion about race, to even engage in offensive and an insulting discussion about race, but you must do so acting fairly and on the basis of true facts, and that was what was absent here.
Okay, so what did the judge find?
He found that there was an infringement of Section 18C, that there was an imputation contained in the articles that would offend not only the particular group of people identified here, but a broader group of fair-skinned Aboriginal people who would feel, as a result of these articles, that they were not entitled to identify as Aboriginal, and that they would have the experience of having their successes questioned, and that other people might respond to them by thinking that whatever it is that they'd succeeded at in life was given to them on the basis that they were Aboriginal. And finally, that there was a sort of dishonest decision to identify as Aboriginal, self-interested decision to identify as Aboriginal in order to receive benefits. And those three negative imputations were thought to be offensive not just to the 9 people here, but to the broader group of fair-skinned Aboriginal people.
Let's talk about some of the wider issues raised by this case. What do you say to the idea that, if somebody does have a certain point of view, the best way to respond to that point of view is to have more media debate, more discussion of the issues, rather than suppressing those issues?
I think that there is an argument to say that people who've been subjected to this kind of insult, based on their race, especially since they're a group subject to historical disadvantage, are actually entitled to have the state intervene and say that there was an unlawful act here. Of course, there is, one path is to take the path of replying, and another path, which is open on the face of this legislation, is to have the state intervene and make a statement that is actually really important, because it would have an effect beyond the 9 individuals here. And the 9 individuals here, they would have had some access to the media to reply. They're prominent. Alternatively, they could have brought a personal action for defamation. But I suspect the reason that they chose to proceed under the Racial Discrimination Act was because it's a very powerful statement about what was said about them that would have an effect of vindicating not just them, but the broader group of Aboriginal people. And I suspect that that was their ultimate concern. And I think that that's the vindication that they're seeking under law.
And what declarations did the judge make?
In fact, the judge has not made final declarations. He's asked for more submissions from the parties on it. But he has made an indication of what he thinks it's likely, and he has suggested that what would be appropriate would be for Mr Bolt and the Herald Sun to undertake not to republish such information, to take the information down from the internet if it is still there, and also to publish a statement on the internet and perhaps in the paper. And that statement's not an apology, but a statement that would acknowledge the finding of unlawfulness by the court. Now, I just would like to point out in relation to those orders that they are significantly less punitive than what could have been achieved by these plaintiffs if they've proceeded under defamation law. I have seen some commentary in the press that said that these people should have proceeded by bringing an action in defamation. Now, that would have been much more restrictive of freedom of expression in one sense, because it would have exposed the Herald and Weekly Times to fairly significant monetary damages potentially. There's no suggestion that that will be an order made by the judge here. In fact, it's not an order I think that is open to him. It's a much less significant order. And could I just reiterate here, I really do want to address this suggestion that somehow it's impossible now to have an honest discussion about race in this country. It is not impossible to have an honest discussion about race in this country. It is not impossible even to have an offensive discussion about race. There is requirement to be fair and reasonable and act in good faith.
Journalists have put to me that in order to do good journalism, confronting direct stories, sometimes that necessarily will be offensive to some people and some groups.
I'm sure that's right. And I think that's what Section 18D, the defence section, is there to protect. It's to make it possible to be offensive in some circumstances, because we do need to have a bold debate, and we do need to have one that crosses some boundaries that some people will not appreciate. We do need to be able to say things that people don't like to hear. Now, Section 18D is an attempt to draw that line. Now, there's always going to be a debate about whether we've drawn the line in precisely the right point.
Professor Adrienne Stone from the University of Melbourne.